Synopsis of a criminal litigation process. Initial contact with the criminal justice system. 1. The criminal litigation process presupposes the prior commission of a crime, or at least the perception that a crime has been committed. There can be no criminal action unless a crime is believed to have been committed. When a crime is committed, there is an offender and generally, there is a victim. The victim may be a private person who may be either a natural or a juridical person. The crimes of homicide, murder or parricide, for instance, are crimes committed against a private individual and classified as crimes against persons. Crimes may, however, also be committed against juridical or artificial persons, as when the offender commits theft or robbery against the property of such juridical persons. Sometimes the offense is not committed against a private person, as when the offense is committed against public interest, like counterfeiting the Great Seal of the government of the Philippine Islands, or committed against public order, like rebellion, sedition or disloyalty of public officers and employees. Crimes may be committed against national security, like treason and other related offenses. A crime may also be committed by the mere possession of goods or things prohibited by law. 2. No matter how or against whom the offense is committed, the mere commission of a crime does not automatically trigger the application of the rules of criminal procedure. The rules come into operation only when acts are initiated that would put the offender in contact with the law. This contact with the law is normally effected when the criminal act is brought to the attention of duly constituted authorities. For instance, the offended party may file a written complaint before the barangay, or in proper cases a sworn complaint before the prosecuting arm of the government. In certain cases, the aggrieved party may initiate the filing of a complaint directly with the municipal trial court. Contact with the law may also occur when law enforcement officers search a place under the control of the alleged offender and seize goods, articles or things found therein. This initial contact may likewise happen when an offender is arrested in flagranti delicto or by virtue of a hot pursuit. 3. There are violations of laws or ordinances which require compliance with the barangay conciliation proceedings originally provided for under Presidential Decree 1508 and now under RA 7160, Local Government Code. Compliance with the procedure set by these proceedings will set in motion the initial contact of the parties with the criminal justice system. RA 7160 establishes the rule that the referral of a case to the Lupon for conciliation or settlement is required before a complaint, petition or action is filed in court. The invocation of judicial authority shall be allowed only if a certification is issued by the proper barangay official that judicial intervention may now be availed of because the desired conciliation or settlement was not reached, or when after a settlement previously forged was repudiated by a party. With the certification to file action, the case is now said to be ripe for filing in court. 4. Not all cases, however, require barangay conciliation. In those cases beyond the ambit of the barangay conciliation process, or where, for instance, the penalty prescribed by law for the alleged offense is at least 4 years, 2 months and 1 day, the rules on criminal procedure begin to grind when a complaint in affidavit form is filed before an authorized officer for the purpose of conducting a preliminary investigation, an inquiry aimed at determining whether a crime has been committed and that the person complained of is probably guilty thereof and hence must be held for trial. Under current rules, the filing of a complaint for the purpose of conducting the requisite preliminary investigation is a way of instituting a criminal action. After the required preliminary investigation has been completed, the investigating prosecutor may either recommend the dismissal of the complaint or the filing of an information in court with an accompanying resolution to that effect prepared by the prosecutor. Such resolution is subject to further action by a higher officer in the prosecution hierarchy, without whose written authority or approval no complaint or information may be filed or dismissed by an investigating prosecutor. Such action may be further reviewed by the Secretary of Justice in accordance with the rules of court and existing Dodge rules on appeal. The Secretary may reverse or modify the resolution of the provincial or city prosecutor or of the chief state prosecutor. 5. There are cases which do not require a preliminary investigation because the penalty is less than 4 years, 2 months and 1 day. In these cases, the complaint or information may be filed directly with the municipal trial court, and such filing, pursuant to the rules, is one of the recognized ways of instituting a criminal action. The municipal trial court may dismiss the same for lack of probable cause after an evaluation of the evidence consisting of the affidavits and other supporting documents of the complainant and his witnesses, or after following the process required in the examination of the complainant and his witnesses. If the court finds probable cause, the court shall issue a warrant of arrest or a commitment order if the accused has already been previously taken into custody, although the judge may issue summons instead of a warrant of arrest if the judge is satisfied that there is no necessity for placing the accused in custody. In places like Manila and other chartered cities which require that the complaint be filed directly with the prosecutor, the said officer shall act on the complaint based on the supporting affidavits and other supporting documents submitted by the complainant and his witnesses. The prosecutor may either dismiss the complaint or file the complaint or information in court. 6. The initial contact with the law may also occur when a person is lawfully arrested without a warrant, either by a peace officer or by a private person. The arrest is deemed lawful when, for instance, the person arrested has committed, was actually committing, or was attempting to commit a crime in the presence of the person effecting the arrest at the time the arrest was made. The arrest is likewise lawful when the arrest was made after a crime has just been committed and the person making the arrest has personal knowledge of facts and circumstances which engenders in him a belief that there is probable cause that the person to be arrested has committed the offense. In any of the cited grounds for a warrantless arrest, the rule mandates that the person arrested shall without delay be delivered to the nearest police station or jail. When the accused is lawfully arrested without a warrant, he shall not, as a rule, undergo a preliminary investigation, even if under the rules, the offense involves a penalty which normally would require such investigation. The complaint or information may nevertheless be filed by the prosecutor after an inquest has been conducted. Where an inquest prosecutor is not available, the complaint may be filed by the offended party or a peace officer directly with the court on the basis of the affidavit of the party or arresting officer or person. Under existing rules of the Department of Justice, the inquest prosecutor may, instead of filing the criminal action, release the person for further proceedings. This occurs when, for instance, the prosecutor finds that the arrest made does not comply with the rules on a valid arrest. The person arrested is then released to be notified later on of a subsequent preliminary investigation. The rule that a complaint or information may be filed against the person lawfully arrested without need for a preliminary investigation is not absolute, because before such complaint or information is filed, the person arrested may ask for a preliminary investigation after validly signing a waiver of the provisions of Article 125 of the RPC. Notwithstanding the waiver, he may apply for bail even before he is charged in court. Even after the filing of the complaint or information, the rule allows the person arrested to ask for a preliminary investigation within 5 days from the time he learns of the complaint or information being filed, and with the same right to adduce evidence in his defense. 7. The wheels of the criminal justice system could also start grinding when law enforcement authorities are in possession of information on possible criminal activities. The authorities may initiate a search and a seizure by virtue of a search warrant duly issued. The search and seizure may also be conducted without a warrant under well-recognized exceptions to the rule requiring a warrant. When the search yields property or effects constituting a crime or subjects of a crime or are means to commit a crime, the appropriate criminal action shall be instituted. Step 2. Filing of the information or complaint and other processes. 1. A criminal action is commenced by the filing of a complaint or an information in court and shall be prosecuted under the control and direction of the public prosecutor, although in special cases, a private prosecutor may be authorized in writing by the chief of the prosecution office or the regional state prosecutor to prosecute the case subject to the approval of the court. 2. The complaint or information is required by the rules to be in writing. The caption of a criminal case contains at least 2 names. The first name refers to the party that brought the action, and this party is denominated as the people of the Philippines. This is because a crime is deemed to have been committed against the people and under whose name a crime must be prosecuted. The second name refers to the person named as offender. He is the party against whom the action is brought. The complaint or information must state the name of the accused, or under a fictitious name when his true name is alleged to be unknown, the name of the offended party, the designation of the offense, the acts or omissions constituting the offense, and the specific qualifying and aggravating circumstances involved. The complaint or information must also state the cause of the accusation against the accused so he may know the offense for which he is charged and also to enable the court to pronounce judgment. The cause of the accusation necessarily includes the attendant qualifying and aggravating circumstances. The date of the commission of the offense, which need not be the precise date, unless the same is a material ingredient of the offense, shall be stated in the complaint or information. Step 3. Implied institution of the civil action. 1. When the criminal action is instituted, the civil action for the recovery of the civil liability arising from the offense charged shall also be deemed instituted with the criminal action. However, when the offended party waives the civil action, reserves the right to institute the same separately or institutes the civil action prior to the criminal action, the civil action is not deemed instituted with the criminal action. 2. Also not deemed instituted are those civil actions which, although may arise from the same acts constituting the offense charged, are denominated as independent civil actions because they do not legally arise from the offense charged and are independent sources of liability. 3. After the criminal action has been commenced, the separate civil action arising from the offense cannot be instituted until final judgment has been entered in the criminal action. Also, if the criminal action is filed after the civil action has already been instituted, the civil action shall be suspended in whatever stage it may be found. Independent civil actions, however, are not suspended and shall proceed independently of the criminal action. 4. The suspension of the civil action when the criminal action is commenced does not also apply to a situation which poses a prejudicial question. Instead, it is the criminal action which may be suspended upon a proper petition on the ground of the existence of a prejudicial question. This question exists when the previously instituted civil action involves an issue similar or intimately related to the issue raised in the subsequent criminal action, and the resolution of such issue determines whether or not the criminal action may proceed. Step 3b. Availment of provisional remedies. When the complaint or information is filed and the civil action arising from the offense charged is properly instituted in accordance with the rules, the offended party may avail of the provisional remedies available in civil actions. For instance, the offended party may have the property of the accused attached as security for the satisfaction of any judgment that may be recovered from the accused when circumstances arise justifying the attachment, as when the criminal action is based on a claim for money or property embezzled by the accused. Step 4. Bail. 1. A person under the custody of the law may gain his release from confinement by availing of the constitutional right to bail, which may be given in the form of corporate surety, property bond, cash deposit, or recognizance. He may apply for bail before or after he is formally charged, and as a rule, the application shall be made in the court where his case is pending, but no bail shall be allowed after a judgment of conviction has become final. If before such finality, the accused applies for probation, he may be allowed temporary liberty under his bail. 2. It is not, however, correct to assume that bail may be availed of only after the filing of the complaint or information. A person in custody who is not yet charged in court may apply for bail with any court in the province, city, or municipality where he is held. 3. An application for bail shall not bar the accused from challenging the validity of his arrest. 4. Bail may be a matter of right or a matter of judicial discretion. Even a person charged with a capital offense may be allowed bail when evidence of his guilt is not strong. That the evidence of guilt is strong is one which the prosecution has the burden of proving. Step 5. Arraignment. Bill of Particulars. Suspension of arraignment. 1. Whether or not the accused is under detention or out on bail, the court shall thereafter set the case for arraignment. Arraignment is the formal mode and manner of implementing the constitutional right of an accused to be informed of the nature and cause of the accusation against him. Without arraignment, the accused is not deemed to have been informed of such accusation. If before his arraignment, the accused escapes, the court has no authority to try him in absentia. 2. The accused is to be arraigned before the court where the complaint or information was filed or assigned for trial. It is made in open court by the judge or clerk and consists of furnishing the accused with a copy of the complaint or information and the reading of the same in a language he understands. He is then asked whether he pleads guilty or not guilty. 3. During the date set for arraignment, the accused need not enter his plea outrightly because before the arraignment and plea the accused has several options. The accused may move for a bill of particulars if there are defects in the information or complaint which prevent him from properly pleading to the charge and preparing for trial. He may also move for the suspension of the arraignment when justifiable reasons do exist for its suspension, as when, among others, the accused appears to be suffering from an unsound mental condition which effectively renders him unable to fully understand the charge against him and to plead intelligently thereto. The accused may likewise, at any time before entering his plea, move to quash, to dismiss the complaint or information. Step 5. B. Quashal of complaint or information. An accused may move to quash the complaint or information on any of the grounds provided for by the rules. For instance, he may move to quash on the ground that the facts charged do not constitute an offense or that the court trying the case has no jurisdiction over the offense charged or over the person of the accused. A motion to quash is a written motion signed by the accused or his counsel which is supposed to distinctly specify both its factual and legal grounds. The motion is filed before the accused enters his plea. If the complaint or information is not dismissed or quashed, and a subsequent plea of not guilty is entered, the machinery of the criminal justice system shall proceed to its natural course. Step 6. Pre-trial. 1. After the arraignment of the accused and within 30 days from the date the court acquires jurisdiction over the accused, the court shall order the mandatory trial conference to consider certain matters including plea bargaining, stipulation of facts, the marking of the evidence, the waiver of objections to admissibility, a possible modification of the order of the trial and such other matters that will help promote a fair and expeditious trial of the criminal and civil aspects of the case. 2. After the pre-trial conference, the court shall issue an order reciting the actions taken, the facts stipulated and the evidence marked. The pre-trial order shall bind the parties, limit the trial to matters not disposed of, and control the course of the action during the trial, unless modified to prevent manifest injustice. All agreements or admissions made or entered during the pre-trial conference shall be reduced in writing and signed by the accused and counsel, otherwise, they cannot be used against the accused. Step 7. Trial. Demurrer. 1. Within 30 days from the receipt of the pre-trial order, trial shall commence. The rule is that once the trial is commenced, it shall continue from day to day as far as practicable until terminated, but it may be postponed for a reasonable period of time for good cause. 2. Normally, the trial begins with the prosecution presenting its evidence, but when the accused admits the act or omission charged but interposes a lawful defense, the order of trial may be modified. 3. When the prosecution rests its case, the accused may now present his evidence, to prove his defense and the damages he may have sustained arising from any provisional remedy issued in the case. However, the accused may, instead of presenting his evidence, opt to move to dismiss the case by presenting a demurrer to evidence on the ground of insufficiency of evidence. This demurrer may be presented with or without leave of court. The court may, for the same reason, dismiss the case on its own initiative after giving the prosecution the opportunity to be heard. If the demurrer filed with leave of court is denied, the accused may adduce evidence in his defense but shall waive the right to present evidence if the demurrer to evidence filed without leave of court is denied. The prosecution and the defense may, in the same order, present rebuttal and surrebuttal evidence. Upon admission of the evidence of the parties, the case shall be deemed submitted for decision unless the court directs them to argue orally or to submit written memoranda. Step 8. Judgment. 1. After trial, the judgment of the court shall follow. A judgment is the adjudication by the court on the guilt or innocence of the accused and the imposition on him of the proper penalty and civil liability, if any. It is required to be written in the official language, personally and directly prepared by the judge and signed by him, and shall contain clearly and distinctly a statement of the facts and the law upon which it is based. 2. The judgment is promulgated by reading it in the presence of the accused and any judge of the court in which it was rendered, unless it is for a light offense, in which case the judgment may be pronounced in the presence of his counsel or representative. Step 8. B. Post-judgment remedies. 1. Before the judgment of conviction becomes final or before an appeal is perfected, the accused may file a motion for the modification of the judgment or for the setting aside of the same. 2. Also, at any time before the judgment of conviction becomes final, the accused may move for a new trial or a reconsideration. A motion for new trial shall be predicated upon errors of law or irregularities during the trial and the discovery of new or material evidence. Within the same period, a motion for reconsideration may also be filed on the grounds of errors of law or fact in the judgment. The court also may, on its own motion with the consent of the accused, grant a new trial or reconsideration. 3. Before the finality of the judgment, the accused may also appeal from a judgment of conviction in accordance with the procedure set forth in the rules. Notwithstanding the perfection of the appeal, the court may allow the appellant, upon proper motion, to withdraw the appeal already perfected before the record has been forwarded by the clerk of court to the proper appellate court. An appeal may even be withdrawn upon proper motion of the appellant before the rendition of the judgment of the case on appeal, in which case the judgment of the court of origin shall become final and the case shall be remanded to the latter court for execution of the judgment. 4. Cases decided by the Metropolitan Trial Court, Municipal Trial Court in cities, Municipal Trial Court or the Municipal Circuit Trial Court shall be appealed to the Regional Trial Court. Cases decided by the Regional Trial Court shall be appealable either to the Court of Appeals or to the Supreme Court in the proper cases provided for by law. Cases decided by the Court of Appeals or the Sandigan-Bayan shall be appealable to the Supreme Court. 5. The appeal to the Regional Trial Court, or to the Court of Appeals in cases decided by the Regional Trial Court in the exercise of its original jurisdiction, shall be by notice of appeal filed with the court which rendered the judgment or final order appealed from. 6. The appeal to the Court of Appeals in cases decided by the Regional Trial Court in the exercise of its appellate jurisdiction shall be by petition for review under Rule 42. 7. The appeal in cases where the penalty imposed by the RTC is reclusion perpetua or life imprisonment, shall be by notice of appeal to the Court of Appeals in accordance with Rule 122. A review of the case by the Court of Appeals is necessary before the same is elevated to the Supreme Court. 8. Decisions and final orders of the Sandigan-Bayan shall be appealable to the Supreme Court by petition for review on certiorari in accordance with Rule 45 of the Rules of Court. Last step, entry of judgment. When all remedies have been exhausted and the judgment has become final, the same shall be entered in accordance with existing rules.